Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and I am back, okay, as promised, a little longer than promised, but I am back nonetheless. I'm trying to wrap up this Northern District of Illinois appeal document that I told you guys I was going to go ahead and get recorded just so you can have it for your reference. And if you're not familiar with what I'm talking about, in the Northern District of Illinois, R&B singer R.Kelly, whose real name is Robert Sylvester Kelly, was found guilty. And back in February, his attorney actually did oral arguments before the 7th District in the Court of Appeals. And so I never did get around to reading the actual appeal documents that came out last year. And so since I went through the Eastern District of New York case and got all of that on record, I decided to go back and pull the documents or read the documents. I've had them all along, but read the documents for the Northern District of Illinois just to wrap up my coverage over the past 4.5, 5 years of Mr. Kelly's case, just to have all of this on record, because I did turn all these videos into a YouTube podcast just so people can have the record if they're listening to that podcast or they want to go back and reference something, they will have the information there. So about a week ago, I did the arguments, well, the summary of arguments, where when she writes out this appeals document, and she is his attorney, Jennifer Bonjean. So there's different sections of the appeal. One is the summary of the argument, where you're basically saying what you are going to argue in the appeal. And then this portion is the actual arguments. And so the Northern District of Illinois appeal was nowhere near the length of the Eastern District of New York case. It was much smaller, very narrow, because this case wasn't as big as the Eastern District of New York's case. So this is not going to take long for me to get through at all. And so for those of you who don't know, in the Northern District of Illinois, Mr. Kelly was facing 13 counts. And he was found innocent of 7 of those counts and guilty of 6. And the media will have you to believe that he was found guilty on everything, but that is not the truth. And in the Illinois case, unlike the New York case, he actually had co-defendants in this case. And the co-defendants were former employees of his. One specifically was his business manager. And then there were 2 other people that for some reason is escaping me. I remember the tall black guy, but I can't remember who the other person was. But anyway, they were, and it might have just been those 2, but they were found not guilty of all charges against them. And then Mr. Kelly was found not guilty of the 7 charges that included them. And this case was surrounding the infamous videotapes from his 2009 or 2008 case, which he was charged earlier in the decade, like in 2000, 2001, 2002, around that time period. And you guys know he was found not guilty in the state case. And this is basically was the federal government's way of coming back and trying to charge him, like recharge him, skirting the double jeopardy laws, which says that you can't charge a person for the same thing twice. And the reason the feds came in and tried him is because there is no connection between state cases and federal cases. So you can be tried for something in the state level, found not guilty, and if the feds want to come back and charge you for that same thing, they can do that. And we saw that with Mr. Kelly's case. So it was just a way of them skirting around the double jeopardy issues by bringing this case. And so this case was talking about, so the appeal, it won't cover the portion of the case that had to do with extortion and all this stuff, and where they was trying to get copies of the infamous videotape with Rishona Landfair, and they were supposedly bribing people, bribed her parents not to testify and all of that stuff. He was found not guilty on all the conspiracy parts of trying to buy back the tapes and that type of stuff. So now we're going to, and you can get more information in the previous videos. I'm not going to rehash all of that. There's a whole bunch of videos out there on the day-to-day court hearings, all the rulings, all the filings. You just need to go through, I believe it's called the R.Kelly series. If you put that in the search engine from my community page, then it'll bring up all those videos for you. So now we're moving into the arguments on the appeals document. And the first argument is the defendant's conviction of exploitation and inducement. Convicted at the state level. So defendant moved pretrial to dismiss his indictment on statute of limitations grounds. Federal Rules of Criminal Procedures 12B1 and B1 and through 2. And so I give you these Federal Rules of Criminal Procedures, the United States versus all these cases that set precedents. I'm going to give you all that information as I'm reading this in the event that you want to go back and do your own research and get more information on what that is all about. So the district court denied defendant's pretrial motion to dismiss. The court reviews the legal issue de novo, United States versus O'Brien 953 F 3D 449 and 454, which was heard in the 7th Circuit in 2020. So federal law imposes a 5-year limitations period for most non-capital offenses. Title 18 United States Code Section 3282A and Title 18 United States Code is basically the United States statutes, is all the statutes that have to do with sex crimes. And so that would be found under Title 18. So over the years, Congress has provided a longer limitations period for offenses involving the sexual or physical abuse or kidnapping of minors. So 18 U.S.C. Section 3283. At the time, defendant committed the conduct for which he was charged and convicted, namely the CP counts 1 through 3, and the inducement counts 9, 10, and 12, Section 3283, provided as follows. No statute of limitations that would otherwise preclude prosecution for an offense, including the sexual and physical abuse of a minor under 18, shall preclude such prosecution before the person reaches the age of 25. And that statute was written in 1994. So consistent with the foregoing provision, at the time of the charged conduct, the statute of limitations for offenses involving abuse were extended until the individual reached the age of 25 years old. Thus, Section 3283 extended the 5-year limitations period for the conduct alleged in counts 1 through 3 and 9 of superseding indictment until September 2009, when Roshana, and they're referring to Roshana Landfair, reached her 25th birthday. The statute of limitations for count 10 was extended until 2005, when Nia turned 25 years old, and the statute of limitations for count 12 was extended until October 2009, when Pauline turned 25 years old. So defendant was not charged until more than a decade after the expiration of the statute of limitations under the applicable law at the time of the alleged conduct. Unless subsequent amendments to Section 3283 apply retroactively, In this case, defendant's convictions must be vacated and dismissed as time barred. In 2003, Congress amended the statute, extending the statute of limitations through the minor of a child. Title 18 United States Code Section 3283, which was written in 2003. Congress did not express an intent for the 2003 amendment to apply retroactively. Consistent with the well-established presumption against retroactive legislation, the 2003 amendment is inapplicable to the charged conduct, as is any subsequent amendments to Section 3283. And then she is directing the courts to the United States versus Deal, DIEHL, 775 F3D 714 720, Fifth Circuit in 2015, applying the version of the 18 USC Section 3283 in effect at the time of the defendant's offense, rather than the amended version in effect at the time of the indictment. And then she has a note on the previous page that says Congress amended the statute again in 2006 to its current version, which provides a limitations period for the life of the victim or 10 years after the offense, which is longer, and that is part of Title 18 USC Code Section 3283. So if in 2006 there was a version which provides the limitations period for the life of the person or 10 years after the offense. So I guess she's saying either way it's time barred and they shouldn't have been allowed to bring it. So then she goes on to say it is axiomatic that criminal limitation statutes are to be liberally interpreted in favor of repose. And then she cites a case, Tracy versus United States, which was a case from 1970. And then it states that retroactivity is not favored in the law. Velasquez Garcia versus Holder, which was a case heard in the Seventh Circuit in 2014. And they were quoting another case, which was Bowen versus Georgetown University, which was a case that was heard in 1988. And the Supreme Court has explained that this aversion to retroactive rulemaking is deeply rooted in our jurisprudence and embodies a legal doctrine centuries older than our republic. Elementary considerations of fairness dictate that individuals should have an opportunity to know what the law is and to conform their conduct accordingly. Settled expectations should not be lightly disrupted. For that reason, the principle that the legal effect of conduct should ordinarily be assessed under the law that existed when the conduct took place has timeless and universal human appeal. Landgraf versus USI Film Productions, and that was a case heard in 1994. With these principles in mind, the district court erred when it retroactively applied the 2003 or 2006 versions of Section 3283 and denied defendants' motion to dismiss on statute of limitations grounds. The United States Supreme Court in Landgraf set forth a framework for determining whether a federal statute of limitation applies to past conduct. The court's first task is to determine whether Congress has expressly prescribed the statute's proper reach. If Congress has done so, of course, there is no need to resort to judicial default rules. When, however, the statute contains no such express command, the court must determine whether the new statute would have retroactive effect. For example, whether it would impair rights as a party possessed when he acted, increase a party's liability for past conduct, or impose new duties with respect to transactions already completed. If the statute would operate retroactively, our traditional presumption teaches that it does not govern absent clear congressional intent favoring such a result. Thus, under Landgraf, if Congress has expressly prescribed that a statute applies retroactively or would not apply retroactively, the inquiry ends. If the statute is silent on this issue, courts proceed to the second step of the Landgraf analysis and determine whether the new statute would have retroactive effects. Here, the 2003 amendment of Section 3283 contains no language expressly prescribing retroactive application of the amendment. Although the statute does not expressly provide that it may only apply prospectively, it employs language that points towards prospective application. The section twice uses forward-looking modal verbs would and shall in Title 18 United States Code Section 3283. No statute of limitations that would otherwise preclude prosecution for an offense involving the sexual or physical abuse or kidnapping of someone under the age of 18 shall preclude. See Appalachian Power Company, which was a case versus EPA, which was a case heard in D.C. in 2001, characterizing the phrase would emit as a future conditional phrase. Salahuddin versus Mean, which was heard in the Second Circuit in 1999. There is no doubt that shall is an imperative, but it is equally clear that it is an imperative that speaks to future conduct. And Martin versus Hunter's Lessay in 1816, now she took it way back, okay? The word shall is sign of the future tense. The legislative history of the statute further supports defendants' contention that Congress used prospective language in the statute to evince its intent that the statute apply prospectively and not retroactively. Critically, Congress considered and rejected language that expressly prescribed retroactive effect, showing its intent that the amendment only applied prospectively. In fact, the House of Representatives version of the bill provided for the complete elimination of a statute of limitations and included an express retroactivity provision declaring the amendments made by this section shall apply to the prosecution of any offense committed before, on, or after the date of enactment of this section. And then it's a Child Abduction Prevention Act, 108th Congress, which was Section 202, written in 2003. The Senate version contained no retroactivity provision. Project Act of the 108th Congress, when the House and State Conference to resolve differences between the bills, the retroactivity provision was omitted. Senator Leahy, one of the bill's original co-sponsors and a former chair of the Senate Judiciary Committee, stated on the Senate floor the omission was intentional. I am pleased that the conference agreed to drop language from the original House-passed bill that would have extended the limitations period retroactively. Senator Leahy Amber legislation, Congress, and that was a hearing that was held in 2003. The legislative history of the bill expresses Congress's intent that the amendment apply prospectively. See Martin versus Haydix, which was a case from 1999, examining structure and legislative history as part of first Landgraf step. See also Food and Drug Administration versus Brown and Williamson Tobacco Corporation, which was a case heard in 2000. Latab versus Ashcroft, which was heard in the First Circuit in 2004. Our inquiry is not limited to the statutory text, but may include an examination of standard ensigns of statutory construction, such as the statute's truck and legislative history. In sum, Congress affirmatively rejected the proposed retroactive application provision, indicating its intent that the statute apply prospectively. Even if this court concludes that Congress's intent is not expressed, retroactive application of the 2003 amendment fails to pass the second prong of the Landgraf test. The United States Supreme Court held in Stogner versus California, which was a case heard in 2003, that retroactive applications of extended statutes of limitations to revive time-barred claims violate the ex post facto clause. The district court held that the 2003 and 2006 amendments did not revive time-barred claims in this case, but rather extended the limitations period for prosecuting those offenses before the limitations period expired. Admittedly, this court, relying on Stogner, has held in different circumstances that extending a limitation period before a prosecution is time barred does not run afoul of the ex post facto clause. See United States versus Gibson, which was heard in the Seventh Circuit in 2007. However, defendant maintains that an analysis of the retroactivity of a criminal statute of limitations under the second step must recognize the principle that unlike civil statutes of limitations, criminal limitations are to be liberally interpreted in favor of repose. Tutsi 397, United States at 115. See also United States versus Gentile, which was heard in the District of New Jersey in 2017, observing that if Landgraf and Tutsi are read in conjunction, courts must interpret the statute of limitations in a manner favoring repose for defendant. As the First Circuit acknowledged, Tutsi potentially alters the second step in the Landgraf approach. In criminal cases, United States versus Miller, which was heard in the First Circuit 2018, evaluating 2003 amendment in adjudicating ineffective assistance of counsel claim. In other words, when Congress has sounded an uncertain trumpet, a court ought to refrain from applying an enlarged criminal statute of limitations retrospectively. As discussed supra, Congress sounded an uncertain trumpet regarding the retroactivity of the 2003 amendment when it affirmatively removed a retroactivity provision from the bill. In light of Tutsi, this court should reject a retroactive application of the 2003 amendment, even if it is not the equivalent of an ex post facto violation, because it runs afoul of familiar considerations of fair notice, reasonable reliance, and settled expectations. Put differently, defendant urges this court to read the second step of Landgraf as providing broader protections for criminal defendants than the ex post facto clause. Statutes of limitations applicable to criminal prosecutions are designed principally to protect individuals from having to defend themselves against charges supported by facts that are remote in time. And then she cites United States versus Rivera-Ventura, which was heard in the Second Circuit in 1995. That concern was acute in this case, where the government sought to rely on the retroactive extension of criminal statute of limitations to prosecute a case based on conduct that is more than 2 decades old. Retroactive application of the 2003 amendment not only flies in the face of congressional intent, it violates notions of fundamental fairness. In sum, Section 3283, by its language and its legislative history, has intended to apply retrospectively. The inquiry ends there, but even if the court examined the question under Step 2 of Landgraf, the analysis, it should decide against retroactive application of the amendment. Accordingly, this court should vacate the defendant's convictions as time barred. Now, of course, you guys know that when the Northern District of Illinois prosecutors responded, They had a very, very long response that was basically opposite of what Ms. Bonjean is arguing in her argument. And then they list cases that they claim were heard and upheld that was opposite of what Ms. Bonjean is saying. So Ms. Bonjean is arguing that they should have gone by the laws that were in effect at the time the alleged crimes took place, not the laws that came along after the fact. So these new laws were written in, or amendments were written in 2003 and 2006. However, Mr. Kelly was initially arrested in the early I can't remember. You guys let me know in the comments. He was arrested in like 2002, I believe it was. So he should be held to the standard of the law that was in place in 2002 when he was arrested, not laws that were put in place after his arrest. Although he went to trial, he didn't go to trial until 2008, and the government argues the opposite. You know, they're saying basically here are some cases that support what we're saying, and plus he went to trial in 2008. Okay, so those were the laws that were in effect in 2008, and therefore his convictions should stand. So I am going to wrap this up here, and I'll be back in about an hour, I promise, with the second part of her appeal in the Northern District of Illinois. So go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.